All right, appearances for the people versus Frank Mishaw Jr.
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
No, it's not. You have work. So
Yeah,
you're on Friday.
Are you right? Please sit at the desk representing yourself.
The judge needs to address you, sir. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry, officer.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to...
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
All right, let's dive right in. Imagine stepping into a courtroom where reality and delusion collide head-on. Frank Mishaw Jr. walks in, insisting he's a sovereign citizen, someone above the law, untouchable, invincible. The judge? Judge Oakley, a no-nonsense authority who doesn't flinch at nonsense. From the very first second, tension ignites. Frank refuses to sit where the court demands, arguing over legal distinctions no one else recognizes. The judge lays down the rules. Either sit in the chair, or a bench warrant will be issued. The air is thick with confrontation, sparks flying as authority meets arrogance. This isn't a polite conversation. It's a war of wills, and the court is the battlefield.
If I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Mishaw.
Are we on the record?
Yes.
Are you on your oath to the Constitution?
Hold on. Are you picking him up? That's one of the reasons I want you up here is there's a microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You have
I took an oath that said I would follow the Constitution.
to not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay? Now I have...
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
may
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I've recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that,
The exchanges escalate quickly. Frank challenges the judge on the Constitution, claiming his allegiance is personal, not legal. The courtroom trembles as Judge Oakley cuts through every evasive maneuver. "Get in the chair or leave," he commands, not threatening, declaring. Frank insists he's representing himself, rejecting the attorney beside him, proving that stubbornness sometimes masquerades as principle. Every attempt to assert control is met with precise surgical pushback. Oakley doesn't just enforce rules. He dismantles illusions, exposing the fragility of pseudo-legal claims while keeping the courtroom's pulse steady.
pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record. So with that being said,
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
so today,
You have a jurisdictional argument you want to make?
what I've served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a.
Yes or
multiple
no?
why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your
Okay,
jurisdictional
so-
argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of Michigan?
District courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
Then comes the jurisdictional debate. A labyrinth of legal theory versus street-level reality. Frank demands clarity. Common law, admiralty, statutory law. He wants the court to define its playground. Oakley responds like a surgeon, dissecting each argument, exposing the gaps, revealing the irrelevance of sovereign citizen rhetoric in the face of state authority. Frank's confidence starts to crack, replaced by frustration. The tension ratchets higher. The audience can almost feel the clash of knowledge versus fantasy. Here, in real time, the courtroom transforms into a proving ground. Logic versus delusion. Authority versus rebellion.
So, okay, is that,
I work
Criminal
under the authority
or-
of the state of Michigan.
what is it, under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty,
What
and
is it?
it's not common law.
Which
It's
one is-
statutory.
Okay, so it's statutory, that is what, civil?
No,
So what is it? For the
My
record, I need to
jurisdiction
have
is
that
both
on-
civil-
I can't defend myself unless I have it on the record. Is it,
my
it's
jurisdiction.
only two?
Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a criminal case.
Okay, right, so is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes,
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
there must be what?
An injured party.
Yeah, it's the
A
people of the
corpus
state of
delicti.
Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan
How can I injure
are bringing the
state?
charges.
How can I injure the state?
Sir, sit down.
Next, the complaint is scrutinized, the alleged harm dissected. Frank demands proof of an injured party, throwing hypothetical legal grenades. Oakley, unflinching, lays down a fact-based hammer. The people of Michigan are the injured party. No theatrics, no debate, just facts and the cold weight of reality. Frank's arguments, once a tidal wave of words, start hitting the concrete wall of law. The courtroom is a crucible of frustration, where fantasy meets consequence. Every interruption, every objection is met with a measured, unapologetic response that signals who's in control.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the
So-
OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name.
Your witness, say yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100.
The audience begins to witness the subtle artistry of courtroom authority. Witnesses are called. Officer Stepan steps forward. Documents are introduced. Objections are lodged and rejected. Frank's attempts to hijack the narrative are constantly neutralized. Every legal maneuver is analyzed, countered, and placed on the record. The courtroom is alive, electric, as the judge balances patience with precision. Oakley isn't just running a hearing. He's orchestrating a spectacle of justice, demonstrating why authority exists to check delusion.
Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people call Officer Stepan. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here.
This is the probable cause hearing.
It says.
All right, stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied not?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objections to the evidence.
That we are having a preliminary exam when I haven't had a probable cause hearing that I did not.
They're the same thing, Mr. Michaud.
On this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference.
Frustration mounts. Frank throws procedural objections like weapons, citing probable cause, pre-trial conferences, and bonding. The judge methodically dismantles each one, explaining step by step why the preliminary exam is properly scheduled and why prior conferences do not negate today's proceedings. It's a lesson in discipline, in legal reality, and in the consequences of misunderstanding or ignoring the law. The tension tightens with every exchange. The courtroom becomes a war zone of words, and the verdict of logic versus ego hangs in the air.
And today is a different date that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate
Have you ever had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
At this point, the pattern emerges. Frank, undeterred by law, driven by delusion, keeps trying to rewrite the rules. Oakley responds with calm, relentless authority, using precision and timing to neutralize chaos. Frank's claims of bonds, power of attorney, and sovereign immunity collide against decades of legal expertise. It's a showcase of what happens when theory meets practice, when someone believes they can bend reality without consequence. The courtroom becomes a crucible, testing every ounce of patience and every strand of legal acumen.
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point did I waive it? Because if it's a hearing or
You
a conference,
didn't
right,
waive it.
so
There's nothing to
do
hold.
I have a right to have a probable cause conference?
No,
What?
you can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause
It's-
conference.
it's-
It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hall and have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he gets to prove his case?
Then comes the pivotal moment. The judge clarifies the difference between pre-trial conferences and preliminary exams. Frank's protests are stripped of context, reduced to noise against the structured rhythm of procedure. Oakley's explanation is surgical, precise, leaving no room for misinterpretation. The viewer begins to grasp the stakes. This isn't merely about legal points. It's about control, authority, and the consequences of refusing to acknowledge reality. Frank's attempts at defiance are increasingly futile. A lesson in humility playing out live before the world.
Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to...
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, the waiver does not preclude him from
Not at all.
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to.
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
Criminal what?
bid bond.
Hold on.
I
What?
requested the bid bond, the performance bond.
The drama reaches another layer as Frank tries to assert rights and objections, all while the court continues forward. Oakley, with authority sharpened by experience, navigates objections, maintains order, and ensures the process continues. Every argument Frank raises is countered not with emotion, but with clear, commanding legal reasoning. The tension is tangible, the stakes high. This is a courtroom in real time, a crucible of ego and law. The audience sees exactly why courtroom procedure matters, why patience, precision, and authority are non-negotiable in the face of chaos.
There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone
I
here
don't-
has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address, okay, so,
I'm not addressing any of that crap you
Can
got in
you-
front of you.
well, since you say you don't have a bond, can you express that in a via affidavit so I can have a?
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent a affidavit of fee schedule for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice and.
Great, then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you
Okay.
said that.
Right, and
Move on.
you haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
am not
recognize
a
any of that.
United States citizen. I am
Stop,
actually
hold on,
identified.
stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent or you can use, tell me that?
As the preliminary exam proceeds, Frank's strategies falter. He challenges bonds, fee schedules, notices, even his identity as a legal entity. The judge, unwavering, crushes each argument with clarity and force. Frank's defiance begins to crumble under the weight of authority. Every interruption, every threat is met with consequence. Oakley's mastery of the courtroom transforms what could be chaos into a demonstration of order, illustrating the stark contrast between the fantasies of sovereignty and the relentless grind of legal reality.
Not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does
Can you
mean, hold
prove
on. It does, it should mean something
Can you
because,
prove it? Please prove it.
can I prove what?
Prove that I am not that I am the artificial person. Period.
I can prove you're Frank
I have
Michaud.
full faith and credit.
I can prove.
Okay, so
Hold on, you've
Are
asked
you-
me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And I
You
actually
proved
you
it for
threatened
me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing. But
Okay?
you still threatening me, and you're using it under color of law.
Okay, listen.
And plus,
Listen
you
to
have,
me. Mr.
you
Michaud,
have, you have
I've
multiple
wasted
officers.
too much time with you. Yes or
Okay.
no?
So
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or
I
no?
object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
The climax is near. Contempt is declared. A fine is imposed. The court holds firm, and Frank's resistance begins to break. The audience feels the tension peak, the collision of delusion and consequence. Judge Oakley doesn't flinch, doesn't negotiate fantasy. He enforces reality. Frank's arguments, no matter how passionately delivered, cannot survive in a courtroom where law is practiced, not theorized. The lesson is brutal, undeniable. Reality doesn't bend to whim or ego, and the courtroom is the proving ground.
Object to that. That's
I'm happy to hear your objection.
due process.
Appeal me. That's why circuit court judges have jobs.
Definitely.
Take him out of here.
Under color of law.
I can give you more than 30 days. John, ask the wife to come in so he can see his property go to his wife. Ma'am, would you accept some personal property from your husband, please?
That was an extreme amount of patience.
Good try.
I appreciate you, giving him as much latitude as you did.
I just can't let him run things. I'll let him engage me and, I don't mind that, but I just can't let him try to run things.
Yeah. No.
Especially when I got 3 or 4 more exams to do.
Right.
The internet is the worst thing in the world for these guys.
I tried to tell him,
It don't play
the
here.
court is going to deny your objection. Let's allow this to move forward. He might have been able to win this.
And that's the worst part about all these
Yeah.
cases, right?
Yeah.
Because sometimes they've got a chance if they just,
We had a good
Ron White,
argument.
right?
Yeah.
Got a constitutional right to remain silent, just can't do it.
You can't fix stupid.
Finally, the courtroom begins to exhale. Oakley ensures fairness, allows the process to continue, and makes clear the next steps in the judicial system. Frank's behavior guarantees more appearances, but the courtroom stands unshaken, a fortress of authority against chaos. As the camera pans out, the lesson is clear. Knowledge, procedure, and authority crush arrogance and fantasy. Reality wins. The video concludes, leaving viewers both entertained and educated. A masterclass in control, consequence, and the raw power of law.